right is still right, even if you stand by yourself.
Mr. Chief Justice, may it please the court.
Welcome to this week's edition of Case in Point, the legal show for regular people. I'm your host, Sarah Parshall-Perry, a senior legal fellow here at our Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. And isn't that a mouthful? And if you're thinking, yes, I look particularly fancy tonight we're celebrating the Heritage Foundation Christmas party. So I'm dressed early for today's podcast, but really looking forward to talking to you. Before we get to our guest at First Liberty Institute today, there are a couple of legal developments that bear noting before we hop in. First of all, let me tell you about what the Supreme Court did not decide to take. It actually dismissed two cases, what's called generally declining or denying a petition for certiorari, Latin, okay? But it just means a petition for review, a request to take up the case. Two cases, we've talked about parental rights. We've talked about gender identity. Two cases specifically related to these two issues were just dismissed at the Supreme Court. The first case is a case called Boston Parent Coalition for Academic Excellence versus School Committee for City of Boston. Now, our friends over at Pacific Legal Foundation brought this. This was a challenge under the 14th Amendment's Equal Protection Clause. Remember, equal protection is at issue. That 14th Amendment is at issue in the gender medicine case we talked about last week with Attorney General Scarametti in the U.S. versus Scarametti case. Remember, it ensures, it protects all individuals in the United States are given equal protection of the laws, but it was a challenge to a racially motivated alteration of a public school district's admission criteria. Why? Because they wanted to reduce the number of Asian American and white students. Now, if you're asking yourself, did we just see this issue with the Supreme Court? Yes, we did. In the Students for Fair Admission versus UNC and versus Harvard College cases, remember, these were the cases in which the Supreme Court determined that, yes, Harvard and UNC had been running an admissions criteria program that was essentially declining some populations, weighting other populations. They said that violates not just equal protection, but the Civil Rights Act as well, Title VI to be specific. That may have been why they kicked it out. But that was a big case that is no longer going to be considered by the Supreme Court. Here's another one, and this surprised me a little bit, but I could have seen it coming. It's a case called Parents Protecting Our Children versus Eau Claire Area School District in Wisconsin. So this one comes out of my home state of Wisconsin, which is the 7th Circuit Court of Appeals. It was a group of parents who were facially challenging, meaning they didn't have any children who were transgender or had gender dysphoria. They just thought this policy was unconstitutional on its face. It was a school district policy that kept confidential from parents any information relative to how their minor child was identifying at school, whether that was different pronouns or gender dysphoria or different names, hiding that information from their parents. Now, this to me is shocking as the mother of 3 children, ages 20 and under. I can't believe we're at this point in American education. But once again, the Supreme Court, and this is actually the second time this term that the Supreme Court's kicked out one of these particular challenges to a school confidentiality policy. But here's a little spoiler. I know of a case in the 11th Circuit Court of Appeals, which is coming up from the state of Florida, that could be actually on its way to the Supreme Court. So there will be an opportunity in the future to rule whether or not policies like this violate a constitutional right to parent one's minor children. Not entirely surprising, and there is still hope for the future. TikTok, which is owned by ByteDance, the foreign corporation that is incorporated in China, took a major blow in the D.C. Circuit Court of Appeals, which is often referred to as the Supreme Court's Supreme Court. Why? Because it hears a ton of cases specifically related to things like, for example, presidential power or corporations that are doing business in D.C. itself. Very high-profile issues often come out of the D.C. Circuit. This one was absolutely no difference. They upheld a law forcing the sale or banning of TikTok in the United States. So now what happens? If the Supreme Court intervenes or Biden grants a 90-day extension before he leaves office, the app stores, if neither of those things happen, are going to have to delete, you heard me, delete TikTok from their platform after January 19th of 2025. Huge blow. Why? Isn't this a violation of the First Amendment? You find yourselves asking, don't we want to protect social media companies? Well, here's why. First Amendment, rating from the opinion, exists to protect free speech in the United States. Here, the government only acted to protect the freedom from a foreign adversary nation, i.e. China, and to limit that adversary's ability to gather data on people in the United States. That is why the First Amendment was not violated. It had nothing to do with speech, simply data harvesting. And in its first official opinion, yes, I cannot believe we've already issued an opinion, the Supreme Court actually weighed in on an immigration decision. This is an opinion written by Justice Jackson, the most junior of all the Supreme Court justices, and it was unanimous, 9-0. Very rare for the Supreme Court to reach unanimity on any of its decisions, especially when high-profile issues like immigration are at issue. But this is the first opinion of the October 2024 term. We're only here in December. And last term, it took them until January before they rolled out something. Justice Brown Jackson wrote for the unanimous court. The case was called Bufara versus Mayorkas, and the question was whether an individual who was trying to get review, a court to review, what's called judicial review, of their visa application, remember, to be in the United States legally, can they get a court to review it after the government finds that they lied on their application for a visa? Or does the statute at issue restrict them only based on the government's discretion to enforce the law? What the Supreme Court held was that, yes, the government in this instance, based on the statute at issue and a plain text reading, and we love those plain text readings, friends, that's called textualism. What does the word on paper say? What did it mean at the time of the statute's enacting? The government agency here, which was the USCIS, that's the U.S. Citizenship and Immigration Service, they had discretion, according to the text of the law, to essentially be the final say. My guest today on Case in Point is Keisha Russell. She is coming to us from First Liberty Institute. I'm excited to talk to her about both religious liberty at the Supreme Court and a new book she has coming out that's going to be specific to everybody here on Case in Point, the legal show for regular people. It is a book about regular expressions of courage. Joining me now on Case in Point is Keisha Russell. She is a constitutional attorney with First Liberty, which is the only law firm, public interest law firm, dedicated exclusively to the defense of religious liberty across the country, something I am very passionate about as we are here at the Heritage Foundation. And she's out with a new book we're going to talk about, and her book releases in January of 2025 called Uncommon Courage. Keisha, welcome to Case in Point.
Thank you so much for having me.
Well, the work that First Liberty does is unique because it is all exclusively religious liberty work, and there's no shortage of it. One would think with the security of the First Amendment behind all of us that some of these issues would be long settled, and yet you guys are representing two different clients in two cases that I want to talk about a little bit and kind of hear from your perspective exactly the arguments that have been made on the other side and how you all are defending these individuals. And the first one is a case coming out of the Supreme Court of New Jersey. Freedom from Religion Foundation versus Morris County Board of Chosen Freeholders. This is actually an exemption by the government of religious organizations, churches, historic churches, denying them historic preservation grants, even though they're giving these historic preservation grants to other historic locations. Tell me a little bit about the case.
Yeah, so this particular grant, the Freedom from Religion Foundation says that it violates the New Jersey's constitutional clause against giving religious or money to religious causes, uses, etc. And the New Jersey Supreme Court actually agreed with that position, surprisingly. The New Jersey AG argued that under the Establishment Clause jurisprudence, which has now moved towards a more of a history and tradition type of analysis, said that, well, it's our history and tradition not to give money to religious causes, not to give government money to religious causes. And of course, our position is that, well, that doesn't work because the last couple of Supreme Court cases on these issues says the government has to be neutral towards religion. So for example, I'll go through just a couple of quick cases. So Trinity Lutheran was kind of the start of this. Yeah. Trinity Lutheran was about a Christian school that applied for a grant to resurface their playground with like the new tire tread kind of recycling program. And they were denied only because it was a religious school. And the Supreme Court said in that case, well, if they meet all the criteria, you can't deny them just because they're religious. That is a violation of the Free Exercise Clause. And then we have the next iteration in Espinoza, which was very similar. That was about Montana having a tuition scholarship program that was not able to be used for religious schools. And again, the Supreme Court said, look, you don't have to fund private schools. You don't have to do all this. The state doesn't have to. But if you're going to fund any sort of private or secular, educational endeavor, you have to fund religious endeavors too. You can't just cut them out because they're religious.
Right.
And then again, in Carson versus Macon, which was one of our cases at First Liberty, the government said the same thing. A tuition voucher program that the state of Maine said you can't use for religious purposes. Supreme Court said the exact same thing. You cannot discriminate against religious churches just because they're churches. And so that is ultimately why we ended up winning this New Jersey churches case, is because all of the recent case law says you cannot do what the Freedom of a Religious Foundation says.
Yeah, that's a great trio of cases, because the Supreme Court clarified over and over again, and every single time that there was a distinction argued by the government, each time the Supreme Court reiterated, listen, if there's a generally available government benefit, it has to be available to everyone, regardless of the religious nature of that organization or that school. So you guys really had some good case law on your side. So you were victorious at the New Jersey Supreme Court?
Yes, we were, thankfully, and our PI was granted. And of course, the church is able to receive this aid now. But this kind of, I think, really demonstrates what has happened in our country in the last, say, few decades regarding the Establishment Clause being used to pretty much ostracize religion from public life. Yeah. Right. And I think what we're seeing now is sort of a correction of that course, but we still have a lot of work to do, because you see, we're still arguing with states and governments and counties and all kinds of people about the right that churches have to be treated neutrally by the government.
I read the case summary in this. At first, I thought what we were talking about may have been a zoning case, right? Because I just took a brief glance at the case. And we talked a little bit on the show about the two sister laws, RFRA and RLUIPA. RFRA being the Religious Freedom Restoration Act, and RLUIPA being the Religious Land Use and Institutionalized Persons Act. Now, we saw a RLUIPA case 2 terms ago in a case called Ramirez versus Collier, and that was where the inmate who'd been sentenced to death row wanted his pastor to lay hands on him. We don't see as often institutionalized person cases, but I thought maybe in this case, the church itself had been denied a zoning permit, and we've seen that as an expression of government hostility as well, not just government grants, but even government grants of zoning applications for use of particular land that's otherwise generally available. Are you surprised that culturally we're sort of continuing down a path of religious hostility, even though the Supreme Court's been very clear on this?
I'm not surprised, because I think the media and sort of the rhetoric that's out there is this whole separation of church and state rhetoric. And a lot of people think they know what that phrase means, but I found that most people don't really know what it means. They also don't know that it's not found anywhere in the Constitution and the First Amendment or anything like that. So they don't know the origins of that particular phrase from, the Thomas Jefferson's letter, which really was about the government staying out of church disputes and conversations and things like that. It
designed ultimately to protect churches, not to protect the government from churches.
Yes, that's right. And so that, I think that phrase has been just so perverted. And now we see this Frankenstein version of it, where people believe that the separation of church and state means no religion can be seen in public life ever. And that sounds really extreme, but that's exactly what's happening right now. Yeah. And what you see taking place in many cases, including the case we're going to talk about here pretty soon.
Yeah. So let's go to that next case, because I actually read the case brief in this instance, and I literally had to do a double take when I saw exactly what the specifics were in this case. This is the Gethsemane Baptist Church case versus City of San Luis. And this is city officials, and this is a tiny Arizona town. It's a border town. They're actually blocking this church from providing. Again, you can hear in my voice, if you're listening to this podcast, the fact that I'm almost having to stifle a laugh. They're blocking the church from feeding the most vulnerable people in the community, and have actually even threatened criminal charges. Please tell me about this case.
Yeah, so this is an Arlupa case. The one you mentioned before is an institutionalized person case in the prison context, but Arlupa also applies in the land use context. And so this is what that kind of case is. It's about the religious use and their ministry on the land of the county, using their food trucks to deliver food and all of this, and everything was fine. I mean, this church has been feeding the community for 25 years, and then all of a sudden it gets a new mayor in 2022, and this particular mayor decides that they don't like this ministry, they don't like this church, and so the county starts to weaponize the zoning laws against the church. So, for example, the county would say something like, well, you can't park there. Your truck is too big. Oh, you're parking for too long. Oh, you're not allowed to feed the homeless. You don't have a permit for this. Oh, this is a commercial use. Now, all this sounds crazy, but it's actually not that uncommon, because a lot of churches, a lot of ministries that I've represented and cases I've been involved in personally, this is the zoning. These are the kinds of zoning restrictions that they use to ostracize the churches. And not only that, to shutter them in some cases and say, you can't do this ministry. And sometimes you can't even meet. So in this particular case, the county's basically said, you can't have this food, service going on. And we're willing to go as far as penalizing you and giving you criminal, yes, I said it.
I was just going to.
For feeding the homeless. Yeah.
So exactly what potential criminal charges were they threatened with levying in this instance? Because that was the part of this case where I found not only unconscionable, but literally it was shocking to me.
Oh, yeah. So we're talking about citations that resulted in thousands of dollars of penalties against this church. Any additional citation that this church gets would result in a Class 1 misdemeanor, heavier fines, and jail time. for feeding the homeless in a ministry. This church has been doing this forever. And now this mayor is completely hostile. The mayor's turned the entire county, the government is a weapon against this ministry. And so that's what's happening. I do have an update here that isn't on the site that I can give you on this particular issue if you don't have any other questions about them.
No, it's so strange to me that we're in an era now of no good deed going unpunished. Mm-hmm. We know Pew Research has told us that the majority of charitable work in the United States is done by religiously affiliated organizations and most often by churches. We're talking in excess of 80%. Yeah. So we know that these are the actual organizations who are doing things like running ministries and soup kitchens and feeding the homeless, feeding the needy. Why anyone would want to weaponize a law specifically designed to protect the use of religious organizations in a particular zoning aspect or land use aspect, and why you would want to turn that into a sword against an organization with a proven track record of doing good for these people is absolutely beyond me. But tell me where the litigation stands right now.
So we filed a complaint and a preliminary injunction. Preliminary injunction just means, court, you need to act right now to give this church some safety while it feeds the homeless. And you must do it right now. It's asking for immediate action. And so the county came to us and asked for a deal, basically, for us to pull our preliminary injunction, which we did, so they could file a motion to dismiss. And the court ruled on that motion to dismiss, and they lost. And the district court judge basically called their arguments nonsensical. So, wow. Yeah. So essentially that motion for dismiss was denied. We'll see whether the county wants to come and have, settle and negotiate. Otherwise, we'll keep litigating. Yeah. So right now the ministry is able to operate under our temporary deal, but in a very limited way. So they can only feed like a fraction of the people that they used to feed. And so we really feel like this is an emergency, and we want to continue fighting this and get that church on the move as soon as possible.
I immediately think of the Fulton versus City of Philadelphia case. Once again, another charitable organization, religiously affiliated, simply wanting to participate the exact same way that other organizations or other charitable sort of mission-driven purpose organizations are able to operate, and once again targeted simply because of the religious nature of the actual organization itself. In the Fulton versus City of Philadelphia case, remember, this was Catholic Charities, Catholic Social Services, CSS, who wanted to be able to work specifically with heterosexual married couples in placing children for adoption and foster care. We've got hundreds of thousands of children who need homes in the foster care and adoption communities. Once again, now listen, they were victorious, which makes me think if you all keep litigating this particular case and it ends up at the Supreme Court, fingers crossed that there's a lot of good precedent to rely on.
Oh, yeah, I totally think they're going to lose. And what I think is most ironic about this case and the Fulton case is that these churches, and particularly that adoption agency, was doing this work for orphans for like 100 years, right? Yeah. Before the government even got involved. So here, this church has been feeding the homeless for decades, right? And all of a sudden, the government comes along and says, well, we want to issue these restrictions on your ministry. And it's pretty clear that this ministry is helping the government. It's not a cost to the government, but they're helping the community in a way that the government doesn't have to. So that survey you talked about before about the benefit of religious ministries on our economy, I think was in excess of about $1 trillion. Yeah. That the government does not have to put out because these churches are actually serving these communities because of their own religious mission and not relying on the government at all. And these cases definitely, I think, are related for that particular reason.
Now, you and I have not had a chance to connect since oral arguments in the United States versus Scrimetti case last week. And I had a chance to interview Attorney General for the state of Tennessee, Scrimetti, on Case in Point. But I'm very curious, and once again, to refresh our viewers, this is the challenge to the constitutionality of a ban in the state of Tennessee for so-called gender-affirming care for minors under the age of 18. I think this is a fairly cut and dry, this is a state's power to regulate. That was a lot of the questions coming from the bench, not wanting to take away the opportunity, the ability to sort of short circuit the democratic process herein and make sure that they could actually enact the laws that their citizens wanted them to enact. But very long oral arguments, about 2.5 hours long. Is that law coming out of the state of Tennessee, in your mind, restricting gender-affirming care for minors, you think it'll pass constitutional muster?
Absolutely, I do. And I think I don't understand how the Supreme Court could find any way that it doesn't, and that includes the liberals. There is no unconstitutional restriction here. This is an age-based restriction, which we have throughout our laws, right? And there's no equal protection violation for this. The government easily meets that barrier to be able to have an age-based restriction on these kinds of life-altering surgeries, right? Yeah. And I don't think there'll be a problem. And I was very passionate about this case because in our amicus brief at First Liberty, we represented a client by the name of Abby Martinez, who is a mother in California, whose daughter was socially transitioned without her approval or knowledge. And then when she wouldn't agree to these life-altering type of medical interventions, her daughter, whose name is Jaylee, was taken from her by the state of California and put into a government-regulated home for several years. This mother was told she could not talk to her own daughter about God, otherwise she would never see her daughter. And she was, berated and just treated so horribly. And her daughter at 17 ended up, while she was living in this group home, ended up committing suicide. And so Abby Martinez lost her daughter to this ideology. And this is precisely why, when we talk about why people need to be paying attention to the law, right? It's not just lawyers using a lot of Latin that's boring and inapplicable to everyday people. People like you and I, right? People who are everyday average Americans who just want to be able to practice their faith, raise their children the way they see fit, trust educators not to indoctrinate, are actually finding themselves, and these are moderate positions. They are not constitutionally controversial. They're not culturally controversial. We simply want to live our lives in peace. And now we're seeing further and further encroachment into the realm of parenting one's own children, the solemn right and privilege given by God to be able to raise children the way one sees fit. But this is a weaponization of the law in which child custody officers made some unilateral determination that a God-fearing mother was not in the best interests of her minor daughter's life. This is why issues like this should matter to everyone right now. Absolutely. It's very serious. And this is the government not just indoctrinating the population, but enforcing these restrictions so that you either obey or you lose your child. I mean, this is not a mild situation. It's very serious. And it's one of the reasons why I wanted to tell Abby's story, because I wanted the Supreme Court to understand that this kind of law, yes, it absolutely protects children from this kind of just outrageous ideology. But not only that, it protects parental rights, which we know is enshrined in the Constitution and enshrined in the First Amendment's free exercise clause, right? So these kinds of, what happened to Abby Martinez, if Tennessee is able to go forward with this law, won't happen to any other parent in Tennessee because of a law like this.
Yeah, absolutely. And we've heard there were originally in the underlying litigation, these were parental rights who, they'd been advanced by a set of parents saying we have a constitutional right to get experimental, controversial, highly damaging, irreversible treatments for our children. But the Supreme Court's never said, no. You have a right to medical care for your children. But we've never said you have the right to this kind of treatment for your children. And I think because we didn't hear any arguments about the parental rights claim, other than Justice Amy Coney Barrett, who said, this part of the argument can still go forward in the underlying litigation, but we're just focused on that equal protection portion of the 14th Amendment. Does every individual in the state of Tennessee have equal protection under the law, or does it discriminate on the basis of sex? I think, like you, Keisha, this is a fairly cut and dry case for the Supreme Court to decide. And upholding the Tennessee law, I think, is also good for not only the rule of law and not only constitutional analysis, but also for democracy. Because these individuals in Tennessee enacted this ban. They enacted it because these were the wishes of their constituents. They were all duly enacted. So I think much like the Dobbs versus Jackson decision that overturned Roe versus Wade and sent the issue of abortion back to the people, I think this is one of the things, at least for my part, I'm hopeful they'll do as well. Yeah. I want to get to your book. I'm really excited about this. It comes out in January, so in just a few weeks. Here we are in December already, which I find absolutely shocking as a mother who has to buy Christmas presents, and a little terrifying, as does my wallet. By the way, we've had a long conversation about this. I want to talk about this book. So the book's title is Uncommon Courage. People get book ideas all the time. Following them through to completion is entirely another thing. Yeah. So you had an idea. Tell me about the idea behind this book.
Well, I think a lot of it came from my cases and talking to Christians about my cases, and also popular cases in the culture, like Masterpiece Cake Shop, for example, and realizing that the church and a lot of people in faith were just completely ignorant to the protections of the Constitution. But not only that, the way the Christian, religion is kind of woven throughout the structure of our government in a way that no other religion really is. And regardless of whether people like that or not, it is a fact. And I think that it's important for everybody to know and understand it. And so for me, I wanted to write a book that was comprehensive but accessible to someone who, say, isn't a lawyer, and that any person of faith, I'm specifically targeting Christians, but I think any person of faith would really find the words that I'm saying valuable in the book. Yeah. Because I talk about the institution of our government, how it was created, how it was structured, why it was structured that way, which is so important, and something that I think is missing from a lot of the sort of communism rhetoric we're hearing right now. Yeah. And I also thought that a lot of historical examples around the world about what communism looks like, what fascism actually looks like, and so that people can identify these things on their own and they don't have to rely on the media to teach them, because we all know a lot of the media is not in the teaching business. They're in the indoctrination business, right?
That's exactly it. What do you hope that the book achieves? What's your ultimate goal? If you could sort of wave a magic wand and say, this is what I'm really hoping this book accomplishes, what would that be?
I think I would want to inform and inspire people of faith in particular to engage in the culture a little more, to have uncompromising positions, to be more brave, to be more bold about what they believe, but also to know why they believe what they believe. And to be able to articulate that in a way that is understandable. Not necessarily everybody will agree with it, but you have to be able to say, why do I believe this? Why do I think this is wrong? Why do I believe this is the proper standard? And that's the goal for my book. And I believe that a lot of young people especially will benefit from it, because so many of them are missing a lot of this foundational information about how our country was structured and why we believe the things we do and put them in the Constitution.
You've been litigating religious liberty for quite a while. Do you include some of the stories from these actual real experiences and cases in the book?
Absolutely. And I think one of the most, pointed things I talk about is even in, okay, so for example, in Scrimeti, one of Justice, Jackson's positions was that the reason that this law can be looked at as not being sex-based is because, well, the interracial marriage laws had both black and white in it. And does that mean this is not a racist law just because it includes both black and white? And
Right.
This position, I think, is so problematic and constantly construing what happened in the civil rights movement to what's going on right now with these conversations around sexuality and gender. They are not the same. And that is something I talk about pretty extensively in the book, because I want people to understand the difference between truth, compassion, and, you know, standing by your beliefs. That doesn't mean you have to open the door to everything. And I also think that this idea of sort of equating the civil rights movement with this movement with sexuality and gender is just really problematic. And I think that's why we've lost so many Americans, and including in the church, over this issue, is because they don't really understand the difference between them.
You know, that's an issue as a civil rights litigator. That is an issue for me that I am incredibly passionate about, because the Civil Rights Act has informed so much of my practice. I did a lot of employment discrimination work early on in my career, and I think equating so-called transgender rights, and the president himself, President Biden, has actually said in public forums, trans rights are the human rights issue of our day. Well, for allegedly a 0.01% population in the United States, first of all, I think it not only misses the point on exactly what a human rights issue is. Just because you don't get to walk into a woman's bathroom if you are dressed like a woman doesn't mean that your human rights, let alone your civil rights, have been violated. But number two, and more importantly, I think, it really does a disservice to the actual gains of the civil rights movement in the 60s. And people like Martin Luther King Jr., who were fighting for the opportunity simply to sit at the same lunch counters. That is not what we are experiencing with the expansion of gender identity. The two could not be more different, but boy, it really does confuse, I think, the average American who wants to be, as you said, compassionate, who wants to be kind. This is something, I think, as Christians that motivates us, that facilitates our views even toward conservatism and even toward our constitutional analysis, right? We're driven by the text itself and what we know it means at the time it was enacted. For us, I think that is, who have played in the space for a really long time, it's very disheartening for me to see language that conflates the two between the civil rights era advances and the Civil Rights Act and now this sort of expansion of gender identity. Does that strike you the same way?
Oh, absolutely. And, what's happening is this conflation of self-expression with freedom.
Yeah.
And
yes.
Problem,
great
right?
distinction.
Like, your ability to express yourself however you want is the same as freedom, which means if I want to express myself any way I want, if I want to say I'm a man or I want to say I'm a little boy, I should be able to do that, and all the laws should protect my self-expression. That is not the type of freedom the Constitution is designed to protect. And when the Constitution, say example for equal protection, your characteristics must be immutable, and gender expression by definition is not immutable. All right.
Yeah.
Like I'm black and that can't be changed.
Right.
Okay? That means equal protection protects me from being discriminated against because of my race. That's not the same thing as me saying, you know what, I don't feel like being a woman today, or I don't feel like a woman, and so the law should protect my feelings,
right,
my beliefs about myself. And those two things are not the same, and they won't ever be the same.
That's exactly it. That is the evolution from an ontological perspective on truth. Truth is truth. It's a straight line. It doesn't change, no matter how you feel about it, to a consequentialist view on truth. Truth is truth as long as I feel good and it makes me feel good. Everybody else's rights be hanged. So last question, Keisha, before I let you go. You've now been informed so much by your own practice and these stories of real people and writing a book that is really needed for the everyday average American. Do you think you'll be looking in the future toward more case law and whether or not that might actually sort of be the progenitor of, future books down the road?
It's certainly possible. I think about other books. Certainly now I think about all kinds of things I could add to this book, right? I mean, the book is never actually done. If you've ever written a book, you know that there's always an opportunity to expand on things and to expound on some of your points and ensure that people really understand where you're coming from. So I think there's a lot there. There's a part of me that also wants to write on Israel, which I didn't think would fit very nicely into this book.
Yeah.
But I did work on a lot of matters affecting Israel during law school, and I realized that that's another area where people are unbelievably misguided. And so I do have sort of a desire to write a book about that at some point, but that's such a complicated conflict that I would want to do it right. And so it's just, right now it's just a thought, but it's something I'm thinking very deeply about.
Well, you'll have to keep those of us here at Case in Point updated on what your plans are for the future. Keisha Russell, it has been wonderful talking to you. Merry Christmas and happy holidays to you.
Merry Christmas to you. Such a pleasure being on. Thank you so much.
Thanks again. Well, friends, that's it for this week's episode of Case in Point, the legal show for regular people. I hope you enjoyed my discussion today with Keisha Russell and a little bit of legal news. Follow us on all of the podcast platforms. You know the drill. I can't recite them all by memory, but most importantly, follow us on X at Case in Point Pod and share our show with some friends or colleagues of yours who could use a little law in their lives. Until then, friends, court is adjourned.